Hey there, curious minds. Today we're unraveling a really quite ingenious piece of South African legislation. It's the Documentary Evidence from Countries in Africa Act of 1993. And it tackles one of those, often overlooked but incredibly complex questions. How do courts in different countries actually trust each other's paperwork?
It's a fundamental challenge, really, in cross-border legal stuff. When documents come from outside a country's jurisdiction, proving they're authentic, proving they're relevant, well, it can become an absolute bureaucratic nightmare. This act, specifically focused on the African continent, it aims to cut through that red tape, make legal cooperation far more efficient.
Exactly. So our mission for this deep dive is basically to explain this act in a clear and engaging way. For everyone, really the general public, aspiring legal professionals, we'll outline its core purpose, explore its key provisions, get into the legal context, and ultimately see what practical implications it has for anyone looking to navigate legal interactions across African borders. Think of it as your shortcut to understanding a vital piece of international legal infrastructure. So to really get the genius of this act, let's step back. Before 1993, imagine a scenario, right? You're in South African court trying to prove something crucial for your case. Maybe it's a commercial contract signed in, say, Zambia, or a birth certificate from Mozambique, or maybe even a police report from Botswana related to some cross-border incident before this act. Admitting each of those documents as valid evidence, well, it would require this elaborate, often really arduous authentication process.
Yes, it absolutely would have. You'd likely need to involve consular officials, get multiple layers of notarization. You might even have had to bring in direct testimony from foreign clerks or officials just to prove that a piece of paper was, well, legitimate. We're talking months, sometimes years of delays. Exorbitant costs, an immense drain on resources, really, just to establish the bona fides of a document. It created this kind of legal chasm between countries that, shared so much history and trade.
Right.
So the state president and parliament of South Africa, when they assented to this act on April 29th, 1993, with it commencing just days later on May 7th, they were explicitly trying to bridge that gap. The act itself states its purpose pretty clearly: to provide for the admissibility in the Republic of documentary evidence emanating from certain countries in Africa and for matters connected therewith. It was about creating a foundational trust, streamlining a process that was, frankly, broken.
So it's about making sure justice isn't stalled by international borders or, unnecessary legal hurdles. And it's important, as you mentioned, that the act specifies certain countries in Africa, not all of them. It's not an automatic blanket acceptance. We'll explore how those certain countries get decided and why that distinction matters a bit later on. Okay, before we jump into the core mechanics of how the Act works its magic, let's clarify a couple of terms from Section 1. They're absolutely crucial to understanding its scope. First up, what does the Act actually consider a document? Because it's probably much broader than you might initially think.
Indeed. And what's fascinating here is how the law, even back in 1993, showed remarkable foresight. It kind of anticipated technological advancements. The Act gives a very broad, very inclusive definition of document. It's definitely not just your typical piece of paper. It explicitly includes any affidavit, certificate, record, photograph, book, map, plan, drawing. But then he goes on. And any documentary recording or transcribed computer printout produced by any mechanical or electronic device, and any device by means of which information is recorded or stored.
Wow.
This expansive view is incredibly critical in our modern data-driven world. It acknowledges that evidence isn't just confined to physical paper anymore.
That's incredibly comprehensive. So it could be a digital file, a database record, maybe even a relevant social media post. Or a satellite image.
Potentially, yes.
Yeah.
If it meets the criteria for evidence, it really covers almost anything that holds information.
Okay. And then we also mentioned designated country. What does that mean in the context of this act?
Designated country, that's absolutely key to how the act works in practice. It basically means a country in Africa that the Minister of Justice has formally named or designated. They do this by publishing a notice in the Government Gazette under Section 4A of the Act. So it's not an automatic inclusion of every nation on the continent. It requires a deliberate, formal step. Often implies a level of diplomatic and legal trust has been established between South Africa and that particular country.
Got it.
And just a quick update for you. The powers and functions of the minister in question, they've actually been transferred. It's now the Minister of Justice and Constitutional Development. That change was effective just before the president assumed office on June 19, 2024. So it's a continuously active portfolio. It's not static.
Right, constantly evolving. Okay, so once a country is officially designated, what's the actual game changer for these documents? How does the Act achieve that shortcut you mentioned earlier? This is where Section 2 really rewrites the rules, isn't it? It feels like the heart of the Act.
It absolutely is. Section 2 is a remarkably powerful legal provision. It's what makes the whole mechanism work. It essentially states that notwithstanding anything to the contrary in any rules of court or in any other law, which is a big statement in itself, a document purporting to have been prepared, attested, certified, compiled, or executed in a designated country shall be deemed to have been prepared in the Republic.
Deemed.
Yes, deemed. What's truly revolutionary here is that it explicitly overrides other existing South African laws or court rules that might otherwise make it incredibly difficult or time-consuming or expensive to admit foreign documents as evidence.
So by deeming a document from a designated country to have originated in South Africa just for admissibility purposes.
Exactly. It effectively bypasses many of the complex, often really arduous procedures usually required to authenticate foreign evidence, whether it's in civil or criminal proceedings. Think of it like a VIP pass at airport security. It doesn't remove the security check altogether, but it dramatically speeds up your passage because it accepts a pre-approved level of trust.
That makes sense.
It simplifies the process significantly, cuts through layers of legal bureaucracy that used to exist.
That sounds like an enormous amount of legal friction just vanishes. Can you give us a concrete example how this deeming might play out in a real court case? Maybe something like a cross-border inheritance or a commercial dispute. How would it simplify things?
Certainly. Let's take your inheritance example. Imagine a South African citizen passed away, leaving property in both South Africa and, say, a designated country like Lesotho. To settle the estate here in South Africa, the court might need to see the deceased's marriage certificate from Lesotho, or maybe a will prepared there, or even a deed of property transfer.
Okay.
Now, before this act, each of those documents would likely require formal authentication, probably by a South African diplomatic representative in Lesotho. Then further steps back here could be lengthy, could be expensive. But with Section 2, because Lesotho is a designated country, that marriage certificate, or will, if it appears on its face to be legitimate, it's simply deemed to have been prepared in South Africa for the purpose of getting it admitted as evidence. The South African court can accept it without all those extra hoops.
Wow, that's huge.
It is. It saves the grieving family immense time, legal fees, and, frankly, emotional stress. It shifts the burden away from proving the document's origin to simply examining its contents, which is what truly matters for justice.
That's an incredibly powerful streamlining effect. But, for the legal system, there must always be safeguards. You can't just let anything in. So while documents from designated countries get this special deemed local status, what conditions still apply to ensure their integrity? It's not truly a free-for-all, is it? Does Section 3 introduce an important but?
You've hit on a critical point.
Yeah.
No, it's definitely not a blanket acceptance, and that balance is vital. For maintaining the integrity and standards of evidence, Section 3 is that but. It basically says that if a South African law requires a document to be prepared or attested or certified by a specific type of institution, let's say a particular government department, or by a person holding a particular office, maybe someone with a certain qualification, performing a specific function, or engaged in a specific activity.
Right, like needing a notary public or something specific.
Exactly. Then a similar document from a designated country is admissible only if, and this is the key part, only if it appears on the face thereof to have been prepared by an equivalent institution or by a person in that designated country holding an equivalent office, qualification, function, or activity.
Ah, okay. Equivalency.
Precisely. So, using your example, if a South African court needs a document attested by, say, a commissioner of oaths or a specific departmental registrar, then the document from the designated country needs to come from an official who holds an equivalent office or performs an equivalent function in their own country's system.
So it's like a quality control check?
It's exactly that, a crucial quality control mechanism. It ensures that while the geographic origin is simplified, the substance, the standard of its preparation or attestation, it maintains a comparable level of reliability, trustworthiness. It prevents, a race to the bottom, so to speak. It preserves the quality of evidence even while the process is streamlined.
Okay, that makes perfect sense. And this idea of equivalency brings us directly to Section 4, because that section outlines who makes those crucial decisions, right? Which countries are designated and what exactly counts as equivalent. Because without those active declarations, the Act couldn't really function in practice, could it?
Precisely. Section 4 is absolutely vital for the practical application and the ongoing relevance of the Act. The Minister of Justice and Constitutional Development, as we mentioned, has two critical powers, exercised through a notice published in the Government Gazette. These put the Act into motion. First, they can officially designate any country in Africa. This is how that certain countries clause from the purpose statement is actively brought to life. It's a deliberate act of inclusion, often following diplomatic talks and assessments of legal systems. Okay, step one, name the country. Step one. Then step two, and equally important for that quality control we just discussed, they can declare that a particular institution, office, qualification, function, or activity in a designated country is equivalent to an institution, office, qualification, function, or activity in the republic mentioned in such notice.
Ah, so they spell out the equivalencies.
Exactly. This specific declaration is what makes Section 3 workable. It provides clear legal guidance on what precisely is considered equivalent for admissibility. Without these ministerial actions, Sections 2 and 3 would just remain theoretical concepts.
What's fascinating here is the dynamic nature of it all, the administrative element. It's not like a static list set in stone back in 1993. It needs the minister's active engagement, their discretion, to expand and define its reach, to adapt to new relationships, evolving legal systems within Africa.
Absolutely.
And we know the Act was last checked for updates on March 28, 2025, and had changes incorporated as recently as October 11, 2024. That clearly shows it's a continually managed, updated piece of legislation, not just gathering dust on a shelf.
It has to evolve. For regional relations change, legal systems develop, the Act needs to keep pace.
So let's bring it all together. What does this all mean for you, the listener? Whether you're a law student learning about cross-border evidence, maybe a business person looking to expand into other African markets, or just someone trying to understand how laws impact international relations, what's the real-world significance here? Why should we care about this seemingly niche piece of legislation?
Well, if we connect this to the bigger picture, this act signifies, I think, a deep commitment to regional cooperation and integration within Africa. It goes far beyond just being a legal technicality. It significantly streamlines legal and administrative processes between South Africa and its African neighbors. It fosters easier movement of people, of goods, of services.
Can you give some examples of those tangible benefits?
Sure. Imagine individuals trying to prove their educational or professional qualifications from one country to another. This makes it less hassle, easier to work or study across borders. Think about businesses establishing contracts. Now, those documents can hold legal weight without prohibitive authentication costs. That facilitates trade, investment.
Makes sense.
And even for critical criminal investigations, this act simplifies securing and admitting evidence from across a border. That's vital in combating cross-border crime. Ultimately, it facilitates justice by removing unnecessary legal friction. It makes legal proceedings more efficient, more accessible across the continent. It's really a foundational piece for regional stability and economic growth.
It truly simplifies what could otherwise be just a massive bureaucratic headache. It acknowledges that, okay, while each country definitely has its unique legal system, its sovereign processes, there can still be functional equivalencies, things that allow for cooperation, for shared understanding.
Exactly. It's a very pragmatic, very practical example of legal harmonization without needing to, unify entire legal codes. It's about finding common ground where it matters most for practical purposes, allowing justice to flow more freely across what might otherwise be insurmountable borders.
Yeah. This act feels like a quiet but really powerful engine for regional connectivity. So we've taken a deep dive into the documentary evidence from Countries in Africa Act 1993. We've unpacked how South Africa proactively addresses the challenge of foreign evidence by deeming documents to be local and establishing equivalency for documents from designated African countries.
It really serves as a prime example of how specific, well-crafted legislative tools can bridge legal divides, make justice more accessible, more efficient across a continent rather than creating isolation. It's a smart, pragmatic approach, really, to a recurring legal challenge, and it fosters greater cooperation.
As you reflect on this, maybe consider how might similar principles, this idea of deeming and equivalency, be applied in other areas, not just law. Could it simplify complex international interactions in trade, education, even cultural exchange? What other seemingly small legal mechanisms might be quietly underpinning major global connections? Something to ponder. Until next time.